All right, now we got everybody. Today I'm going to finish up a lecture on employment law, and then next Tuesday we have a guest speaker. We'll either be in this room or we'll be in the auditorium downstairs. If we're in a different classroom, I will let everybody know. I will put a sign up on the door, but I'll also send out an announcement. And I'll put that in our. I'll make sure that I'll do my best to make sure you know about it. Please make a point to come to that class. I know that you all have, some of you may have absences left to use, and that's fine. I leave that up to your discretion. But I would ask you to do me a favor. If you can come to that class, please do, because we have our guest speaker is giving their time and taking time out of their regular job and life to come and speak to y'all. So I would like for us to have a really good crowd. My 11 o'clock class will hopefully as many of them will be joining us as possible. You don't need to do anything to prepare. You just need to come and listen. I will give you an assignment that'll be something like, tell me 3 things that you learned or that you thought were interesting from the guest speaker's remarks. And if you can give that back to me, that'll be an easy 100. There's nothing due this week. Next Thursday, we'll discuss the cases that I've assigned for this unit and maybe a couple other things. And then you'll have a quiz on employment law due the following Monday. And then that'll take us to the last week of the semester. Any questions on where we are, where we're going, where we're headed? We talked a little bit about your interviews. Please make sure you get all those scheduled. We're running out of time on that. So I want y'all to go ahead and, sounds like almost everybody has gotten that done, which is good. Any questions? All right, let's finish up employment law. So I talked a little bit on Tuesday about employment discrimination and the idea that there are federal laws that protect employees from being discriminated against on the basis of their membership in a protected class, or if the employer perceives them as being a member of a protected class, even if they may not be. An example of that was if I'm an employer and I don't want to hire this applicant because I think that they look foreign. I'll use the word foreign, but they're 10th generation Americans. They're born. There's nothing foreign in their ancestry going back to Christopher Columbus. But if I regard them or perceive them as being from another country and I discriminate on that basis, that would be illegal. So membership in a protected class or the perception of being in a protected class or having the characteristics of someone who is in a protected class. The main anti-discrimination federal law is the Title VII of the Civil Rights Act of 1964. So I do want you to know, I don't ask you many names of laws, but I do want you to know that one. We talked about sort of how an employee who is discriminated against would go about bringing a discrimination case. They would file their case. They would assert that they were discriminated against on the basis of their membership in X class. And then the employer would have to give the court their legitimate non-discriminatory reason for the employment decision. And then the burden would shift back to the employee to prove that that reason was not real, that it was just pretext or cover, and that the actual reason was discriminatory. That's how an intentional discrimination case plays out. Unintentional discrimination. Well, let me back up again. We talk a lot about discrimination in terms of hiring, right? But discrimination can take the form of not getting promoted or firing someone for a discriminatory reason, denying an employee certain privileges because of a discriminatory reason, treating employees differently in terms of their hours or their work duties or other things that have to do with their employment. So it's not just hiring and firing. You're being treated differently in your job because of your membership in a protected class. You're being treated differently than other employees who are not in that protected class, then that could also be discriminatory. Intentional discrimination is when I as an employer make a decision. I don't hire you, I fire you, I don't promote you, I give you different work hours. I make decisions intentionally based on your membership in a protected class. But discrimination can also come in the form of unintentional discrimination. That could happen if a company has policies uh, in their hiring, firing, treatment employees that on their face are not discriminatory. But the result of these policies ends up being discriminatory. Here's an example of that. Let's say that I'm a large corporation and I want to hire in my sales positions, which I have thousands of sales positions, let's say. Part of my hiring process is I require all applicants to take a test. Okay. There's nothing discriminatory about the test on its face. It doesn't say anything like, tell me your color or what sex are you. It's just asking maybe general knowledge questions or things like that. It's not discriminatory in and of itself. But if I have 5,000 applicants for my sales jobs, half of which are women and half of which are men, and I require everybody to take this test, and as a result, I hire based on test results, and I'm hiring 90% women into these sales jobs. The men who are not getting these jobs might have a case to say, I know you're not intentionally discriminating against men, but there's something going on in this test that is screening out men. And the result of it, even unintentionally, is that men can't get these sales jobs because this test is somehow favoring, it maybe has some implicit bias towards women. This is the argument that some people make against standardized testing, that there's some inherent bias built into the questions. Y'all have heard this argument made about the SAT or the ACT and that kind of thing, that it's not designed to be discriminatory, but if X group, race or gender or socioeconomic group or religion ends up failing the test or doing worse on the test in a way that's disproportionate to their representation, then that could end up being discrimination. These are cases, unintentional discrimination mostly is, think of it in like class action. It's very large groups of plaintiffs, and it would take a large amount of data to prove. Because remember, this is not like we're going in and we got an email saying, hey, let's design a test that, screens out men. That would be intentional discrimination. There's nothing like that going on. So the proof really is going to be statistical. Hey, there's nothing that we can look at in this test that's in and of itself discriminatory. But when you look at the results, something has to be going on. All right, so the larger statistical group we have, the better numbers or the better case we would have for unintentional discrimination, if that makes sense. Damien.
So let's say if a company, in the process of hiring somebody, they ask for an availability chart, and let's say somebody who maybe religious might mark off the page that they would observe their religion, be it Saturday, Sunday, Wednesday, whatever day that may be, and then somebody notices a trend that people who mark those specific days off are not getting hired on. Would the business be able to fight that? Would they say, oh, the business needs people on those days, or?
Oh, so I would come at that from three different ways. That's a good question. The first is that, well, maybe four different ways. They shouldn't be asking anything about what religious days you would need off, because that's facially discriminatory.
Well, if the question was just, what is your availability?
What's your availability? Okay, yes, and it ends up that a certain religion is going to answer that question in a way that is getting them screened out. That could be unintentional discrimination, sure. Um, where I was going with it was, we'll talk about in a second, with things like religion and disability. Employees are allowed to make requests for reasonable accommodations. But your question was different than that. So, yes, great question. If the interview process or the question mentioned anything about religion or religious holidays or zoned in on that, then we'd be more intentional discrimination. But your question is a very good one. It was just availability. And it so happens that this one subset of religious people would answer that in a way where they would be screened out. Yes. Let's say that I have a factory in the metropolitan area that I hire from is 75% minority. Okay. But the racial makeup of my workforce is overwhelmingly white. Okay. We might not be able to find anything within the hiring process where anybody said we're not going to hire minorities, or the testing or the interviews aren't necessarily discriminatory on their face, but there's something going on if 75% of the available workforce is minority and 80% of the people that we hire are non-minority. That something is going on discriminatory there. It's hard to prove. And like I said, it's the more statistical evidence you have, the stronger your case is. So it would be harder for, like, just, oh, I tried to get a job at this place here in Columbus that has 50 employees. I'm making up, and I think that the test is unintentionally discriminatory, but they hired 13 people over the last 2 years, and 4 of them were men and 9 were women. Yes, that's a higher percentage of women, but is that statistically significant? Probably not a large enough sample size. All right, so that's sort of the difference between intentional and unintentional discrimination. In instances of religion, employers are required under Title VII to provide reasonable accommodations to their employees based on their religious practices. That might be, I'm Jewish and we observe Jewish holidays that don't match up with the Christian holiday calendar. And so I'm going to need to be out these 12, they're the 12, however, I don't know. There are 4 Jewish holidays that I'm going to need to be off of that, not everybody else has. And I'm sure that's not just limited to the Jewish religion. There are other religions that would have their own holidays. Employers are required to make those accommodations. All right. The only limit on what an employer doesn't have to do is they don't have to make accommodations that result in undue hardship. So let's say that I have someone apply to work for me for third shift. All right. And they request an accommodation to only work during daylight hours because their religion prohibits work. I'm just making this up, that their religion prohibits them working when the sun goes down. But they're applying for third shift. I'm not required to accommodate that because there is no accommodation I can make during third shift. It's all during the dark hours. Okay. If I hired somebody and they were already working for me, and I wanted to move them to third shift from second shift, then I might be required to give them that accommodation that, hey, you're exempt from third shift because that goes against your religious practices. If I'm open 5 days a week and the religion is that they can't work during weekdays, I'm not required to accommodate that. Sometimes religious accommodation takes the form of, I need my breaks to be at a certain time so that I can pray. or I need a certain amount of breaks. I need to be able to wear certain clothing because my religion requires it. As long as those don't present an undue hardship to the business, then they're required to make that. The other sort of tricky nuance of accommodations is that there's not any list that an employer could consult of like legitimate religions and legitimate accommodation requests. The law just says that if the employee genuinely and sincerely holds the belief, then that would be enough for the employer to have to consider making the accommodation. Meaning that I mean, I could in theory make up a religion and just say I can't teach 8 a.m. classes. It's against my religion. All right. CSU would have to evaluate that. I mean, they would be allowed to say, well, what is the religion? What's the basis of what is the conflict between your religion and an 8 a.m. class? They would be, it would be legitimate for them to try to test whether or not I sincerely hold this belief, or else I just created a religion and made that up so I can get out of teaching the 8 a.m. classes. I mean, I can't, that doesn't give me license to just make up anything I want. All right. But there is no list necessarily of approved religions or approved accommodations. Gender discrimination, I'll mention on that for a second, that does include pregnancy discrimination. So if an employer makes any decisions based on, whether or not the female employee might get pregnant, or they don't want to deal with maternity leave, or they don't want to deal with a mother who has young kids that get sick or might need to be picked up from school, that would all encompass gender discrimination. It's not necessarily saying I'm not hiring you because you're a woman, but it's discriminating because of characteristics and things that are inherent to being a woman. There is something called constructive discharge, and that protects employees when no adverse employment decisions have actually happened. Like, I didn't get fired, but my employer made my working life hell to the point that the only choice I had was just to quit. Okay? That's constructive discharge. Yes, I know I quit, but really they fired me because they made my work life so bad and so oppressive that I just didn't have any choice. So they really did effectively fire me. That's what constructive discharge is. Okay, part of sex discrimination is sexual harassment. And so you guys have probably all heard of that. Sexual harassment can take a couple of different forms. One is straight up quid pro quo sexual harassment. Quid pro quo is Latin it means something for something. I will give you a raise if you sleep with me. I will let you off for the rest of the afternoon if you let me watch you walk down the hall from behind. I don't know. Something for something. We're going to have your performance review at the Motel 6. That's a reward for something having to do with sexual. That's quid pro quo. But sexual harassment can also be hostile work environment. Okay, if I walk by the dean's office every day on the way to my office, and she whistles at me and catcalls at me every morning, okay, she didn't say, if you want to stay employed, you better do this for me, or I shouldn't use the dean specifically. Any employer, okay, if I'm an employee. But if they're making me feel uncomfortable and the basis of that is something sexual, then I could have a case for hostile work environment. I haven't gotten fired, but I am being forced to work in an environment that is toxic and that is discriminatory based on my sex. Okay, that could be hostile work environment. That's all illegal as sex discrimination. So sexual harassment falls under sex discrimination. While we're talking about sexual harassment, hostile work environment, Title VII protects employees from a hostile work environment, not just on the basis of sexual harassment, but based on their membership in a protected class. So that could be race, national origin, gender, all these other things. If your employer or your coworkers or your working environment is hostile um, because of your membership in a protected class, that's hostile work environment specific to that particular class. Like, let's say that I'm Catholic and my boss makes Catholic jokes all day. Um, that could be a hostile work environment. It has to be, the law does say that for hostile work environment, it has to be severe and pervasive and not just like a one-off comment or an isolated incident. That doesn't mean that that's okay for somebody to make an off-color joke or make a racially motivated joke or comment or something like that. It just means that for hostile work environment claims, it has to be severe and pervasive. Um, Another way that Title VII protects employees is in when it comes to retaliation. So if an employee makes a complaint about their work environment or about an action that their boss has taken or about an action that applied to them, I got written up for being late to class. And I believe that that was discriminatory because I can tell you right now that every other female on this faculty is 15 minutes late to class, and none of them, I'm making this up, and none of them got written up, but I got written up. Okay. I'm claiming that that's uh, discriminatory. And then if the dean all of a sudden reassigns me to all 8 a.m. classes or changes some term of my employment to where I feel like she's doing that because I made a complaint about it, that's retaliation. So employers are not allowed to take action against employees who make complaints for discrimination. Yes.
So, like, I guess since you're on retaliation, like, that is like more of a niche question, I guess. But like, if you're working for like a small business
Mm-hmm.
and like you know you just like you're like friends with like the owners and stuff, and you know something happens outside of work, like with them, who are like you know the families like your bosses.
Okay, I follow.
Yeah, and then you say something. It's like something happens with one of them, and then you say something to the other one at work about it because it's like creating a you know hostile workspace, and then they're fired. Is that like?
It would have to be, the retaliation would have to be in response to a legitimate complaint about working conditions or work environment that was related to membership in a protected class. So maybe there's just drama. I know this family. I dated the boss's daughter and then we broke up and all that. That's not necessarily going to be retaliation. It would have to be something related to the employment environment or the job itself. Did I answer your question? Sort of. Okay. You would want to relate it to official job things. Yeah. Yeah. There is a nuance in sexual harassment and hostile work environment of all kinds in that if it's being done by coworkers and not superiors or managers, in order for the employee to be protected, they've got to make a complaint about it. Like they've got to give the employer or the manager, the supervisor, a chance to do something about it. Okay, so in order for me to sue, let's say that I walk down the hall to my office and Professor X whistles and catcalls at me every day. And that makes me uncomfortable. I feel like it's a hostile work environment. If I don't tell HR or tell the dean or tell my department head and give them a chance to do something about it, I can't sue for it yet. It doesn't mean it's right and the person can keep doing it, but I got to let them know. An exception to that, and I'm not getting in the weeds with this in terms of quiz on you, so don't worry about that. An exception is if the management should have known. Like, let's say that the dean's office, that the dean's assistant is the one that's whistling and catcalling at me every day. I haven't reported it, but the dean should know about it because the dean hears her do it every day. Okay, that might be an exception to that you have to report it type thing. Generally, HR departments in your larger companies are your friends. If you have questions about your rights or whether or not you're being discriminated against or whether or not you need to make a complaint, generally that's the place to go. The larger companies, you're probably more insulated and protected. The smaller companies, I can see where employees would be a little more reluctant to go to HR because they're pretty sure that HR and the head of the company or management talks every day and it would get back to them. So that does put employees sometimes in a little bit of a weird position. Next in your outline, I'm looking at age discrimination. I think we talked about that Tuesday. That applies to anybody over the age of 40. I think I skipped over this. So let me go back to the role of the EEOC, the Equal Employment Opportunity Commission. That is a federal agency, administrative agency under the executive branch, and its job is to enforce and make rules for Title VII of the Civil Rights Act, federal employment laws. So one of the requirements that it has is that if you want to sue your employer for discrimination under any federal law covering the age or covering Title VII or covering disability or any of the other ones, you first have to file a complaint with the EEOC. You cannot go directly to court without first having gone to the EEOC. In theory, the EEOC's job is to screen out these claims, to ease the burden on the court system of having to face the onslaught of all these complaints up front, to make it easier on employees to maybe start a case without having to hire a lawyer or go through all this stuff. And maybe the EEOC can help resolve these complaints without resorting in them overflowing the court system. The EEOC also has the right or the ability to review a complaint and then say, this is so bad or this is so widespread that we're going to sue your employer for you. That doesn't happen very often, but they do have the right to do that. What happens in the vast majority of cases is that the EEOC reviews the complaint and they either say, we do find cause or we don't find cause. We think your complaint has merit or we don't think your complaint has merit. And then once you've gotten their word on that, then you can go to court. What the EEOC says has no bearing in court. So they might say, yep, looks like you got cause, check here, you can go on, you got your ticket to go on to court. You don't then get to go to court and say, well, the EEOC found that there was something to this. Similarly, if the EEOC says we don't really find cause, but hey, now that we've reviewed it, here's your ticket, you may go on to court, you can do that. And the employer doesn't get to go and say, hey, guess what, judge and jury, the EEOC said there was nothing to this. It's just simply a review step before you go to court that screens out some things, that allows the government to involve themselves in serious or egregious cases, and take some pressure off the court system by not having that be the first step in an employment discrimination case. That's the EEOC process. When I worked in my first job after law school, I did employment law for a big firm in Atlanta. And one of the things that we had to do for some of our clients were we had to respond to EEOC complaints. So employees would complain, say, oh, I didn't get this promotion because of my religion. And then our job was to write up a response to the EEOC so that they could make their determination on whether or not there was cause or not cause. One of the partners that I worked for, I thought this was interesting, and I think there's a lot of wisdom in this. One of the partners that I worked for said, my strategy for EEOC complaints is I'm not going to say anything because they're going to be able to sue no matter what. And I'm not giving them any of my evidence right now. I'm not fooling with the EEOC because it doesn't matter what they say. I'm just going to say whatever and let the EEOC make their determination that there was cause or whatever, and the person has their ticket, and then they can go on and sue if they want to do that. But we're not going to waste our time showing our hand or showing our cards at the EEOC stage. The other thing that he didn't like that I agree with was he said, what we put in the EEOC response, that could be used against us later. Like if I say here was the reason why we did this in my EEOC response, but there's really more to it later. Not that I lied or hid anything, but it just turns out later that there was more to it. I don't want that to be used against me in court by a lawyer saying, well, now you're saying it was performance is why this person got fired. But in your EEOC complaint, you didn't say anything about their performance. You said it was because they couldn't get along with people or something. I just don't um, how I handle my to-do list.